Welcome, and thank you for joining us for our webinar, LIBOR is Ending. What do you need to know? Today's webinar will provide a high-level overview of the transition from LIBOR and address, among other things, the current timetable for LIBOR's demise. My name is Sylvia Shin, and I'm a partner at Saul Ewing Arnstein & Lear's Public Finance Practice Group. I will be serving as your moderator for today's program. Before we begin, there are a few housekeeping announcements that I need to make. First, questions can be submitted through the Q&A tool located at the bottom of your screen. Time permitting, we will do our best to answer as many questions submitted at the end of the program. Second, for those interested in obtaining continuing legal education credit for this webinar, today's program has been approved for distance learning CLE credit in Delaware, Florida, Illinois, Minnesota, New Jersey, New York, and Pennsylvania, with an application pending in Virginia. As a CLE provider, we must be able to verify your attendance. Therefore, at random points during this presentation, we will display and verbally announce two numeric reporting codes that you must record and report back to us using the CLE survey that you received in your webinar reminder email. The survey will automatically be open and be available to you at the end of this webinar. Once we receive your survey responses, we will then process the credit and send your certificate of attendance via email. Please be sure to respond to the CLE survey with your numeric codes within 5 days of the program. Third, following the program, you will receive a thank you for participating email that will include a link to the presentation materials. That email will also include a link to the CLE reporting survey, as well as a link providing access to the program recording. And finally, I need to read the following legal disclaimer. The provision and receipt of the information in this presentation, A, is not legal advice, B, does not create an attorney-client relationship, and C, should not be acted on without seeking professional counsel who have been informed of the specific facts. I now would like to introduce you to our panelists. We have two bankers from Ziegler on our panel today. Amy Castleberry is Managing Director of Senior Living Finance at Ziegler and has served the senior living industry for more than 20 years. Amy is responsible for providing investment banking services to not-for-profit senior living providers throughout the Mid-Atlantic region. Our other banking panelist is Scott Dieterman. With nearly 20 years at the bank, Scott is Director of Ziegler's Capital Markets Structured Products Practice. In his role as Director, Scott is responsible, his responsibilities include product and capital structuring, derivative pricing, product presentation and execution, and comprehensive product risk evaluation. From Saul Ewing Arnstein & Lear, we have Josh Pasker and Randy Coulon. Josh is a partner and the Vice Chair of Saul Ewing Arnstein & Lear's Public Finance Practice Group. Josh resides in our Philadelphia office and focuses his practice on municipal finance matters, serving as bond counsel, underwriters counsel, issuers counsel, and borrowers counsel in a broad array of financings. Randy Coulon is counsel in the firm's Public Finance Practice Group and resides in our Chicago office. Randy focuses on tax-exempt finance, banking and secured lending, and corporate law, and he has more than 38 years of experience in a variety of complex financial transactions. And with that, let's begin. Today's program will look to provide an overview of the following: an introduction to the LIBOR, including a discussion on the issues with LIBOR contracts, a review of the LIBOR timeframe and milestones, and considerations on alternatives to LIBOR. We will also look at LIBOR in the municipal bond market, as well as take into account tax, disclosure, and accounting considerations. We will discuss possible legislative solutions, and finally address what needs to be done next. With that walkthrough of the agenda, I will pass the mic to Randy to start the program off with an introduction to LIBOR.
Okay, thanks, Sylvia. I pull up the, sorry, one more. What I guess we're talking about today is, what is LIBOR and why do we care about it? Why are we discussing it today? You probably know LIBOR is the London Interbank Offered Rate, It's basically an average rate based on the small number of banks' daily estimates of their cost to borrow unsecured funds from each other. It's administered out of London and published in 5 different currencies: the Swiss franc, the euro, the UK pound sterling, the Japanese yen, and the US dollar. And it's for maturities of 1 day, 1 week, 1 month, 2 months, 3 months, 6 months, and a year. It's been a fixture in the global markets for over 30 years and serves as an interest rate benchmark for at least 400 million of financial products that range from derivatives to mortgage loans. It includes 200 trillion of US dollar denominated contracts alone. As a result of that, LIBOR is often called the world's most important number. But as Scott will determine later on, its days are numbered. LIBOR is governed by several different entities, both here and in the UK. The Intercontinental Exchange Benchmark Administration, called IBA or sometimes ICE, is the entity that calculates LIBOR by asking major global banks in the London interbank market to report daily the interest rates at which they would lend to each other for short-term loans. The FCA, the Financial Conduct Authority, is the UK financial industry regulatory body with oversight of LIBOR and the IBA. The FCA is really the entity that got this ball rolling and decided to pull the plug on LIBOR in the first place. Over here in America, the Alternatives Reference Rate Committee, or AARC, is a group of private market participants which are tasked by the Fed and the New York Federal Reserve Bank to develop an alternative rate to LIBOR. And they've been coming up with many different scenarios, a different language to use. In addition, the International Swaps and Derivatives Association, or ISDA, is the trade organization of participants in the market for over-the-counter derivatives, and they're formulating alternatives for LIBOR in the international derivatives markets. Even though LIBOR's been around for 30 years, cracks are beginning to show in its use. First of all, over a decade ago, there was the LIBOR scandal, in which traders at some of the major banks deliberately colluded to manipulate LIBOR by either submitting artificially high or artificially low interest rate bids, and that resulted in a lot of fines, actually criminal charges, and basically an overall distrust of the use of LIBOR. LIBOR is based on unsecured loans that the banks lend to each other, so it builds in a risk premium, and that can lead to volatility. The underlying market for interbank loans is small, and LIBOR is now really derived from expert judgment of these limited number of bankers instead of actual transactions. So the FCA and other regulators have determined that the way LIBOR is calculated nowadays really is no longer compliant with sound international principles for interest rate benchmarks, and they decided that it needs a change. LIBOR is sometimes now called zombie LIBOR because it's really neither dead nor alive. Nevertheless, LIBOR is still an important part in the municipal bond market. It's used by governmental entities like states, counties, municipalities, school, library, park, and other districts. It's also used by conduit borrowers, such as 501c3 entities like hospitals, CCRCs, private universities and colleges, and even in private activity bond issues involving manufacturing. It's used in various form of LIBOR-based products, such as floating interest rate bonds and notes, swaps and derivative contracts, used in direct placements with banks and other institutions, lines of credit and loan agreements, leases, installment agreement, sales agreement, and investment. So it's really used in a lot of different areas. And now Scott is going to be talking more about how we're transitioning out of LIBOR.
Okay, thanks, Randy. I appreciate that. And I'll just jump us to the next slide here. There we go. Okay, so to dig into some of the contracts that are pretty common in the tax-exempt municipal market, we thought we would start with kind of 3 different examples. And all these examples that we go through in the contracts, you'll see that the core problem is an insufficiency of how they address the permanent discontinuation of LIBOR. And as a result of a permanent discontinuation of LIBOR, that can lead to a transfer of value from one contract holder to the other. So with these 3 examples, the floating rate note, the first one, it's not as commonly used in the municipal space, but some of the audience members may have some exposure to floating rate notes. And to take a look at these contracts, they are going to be publicly issued bonds that are in the market, of course, on a floating rate basis, oftentimes indexed to 1-month LIBOR, 3-month LIBOR. And the way that these contracts typically address an unavailability of LIBOR is that they typically will reference the last reset that was set on the contract itself. So that may work well with a temporary disruption in the market, say over a 2, 3, 4-month period. But for a permanent discontinuation of LIBOR, you can see how that could cause a pretty significant problem, really converting a floating rate liability of a borrower to a fixed rate liability. And same thing from an investor standpoint, concerns there as well. The direct placement loan, this is where we think that probably the majority of the audience is going to have the most amount of exposure on, and where you'll spend the majority of your resources as you evaluate your LIBOR risk. And with the direct placement loan market, some of the problems with it as it relates to LIBOR is that it's very much fragmented and not standardized. So when you look at your direct placement loan, it's going to have very specific language in your contract that addresses LIBOR discontinuation. If it was a contract that was done, say, 3, 4 years or more ago, it may not even contemplate a permanent discontinuation of LIBOR. It may just really factor in a temporary discontinuation. The direct placements that have been done more recently, say the last couple of years, have evolved, and their language does sometimes include more mechanical description of how LIBOR would be addressed upon a permanent discontinuation, and it could refer to fallback rates that reference, say, prime, Fed funds, or some other rate that could be determined by the lender of the contract. And then with derivative products, if you have swap transactions, say, that are managing the floating rate liability of the direct placement loan, a little bit better place, because the derivative contracts are going to be based on standardized documents. The ISDA master agreement, the 2006 ISDA definitions govern those types of contracts. But when they were originally put in place, again, there was some insufficiencies here, where the contracts themselves, the definitions themselves, really was geared towards a temporary dislocation. And what would happen under the original definitions, if LIBOR is not published, is that the calculation agent, typically the lender or the swap counterparty, who could be the lender or the swap dealer, would survey to a polling of London banks. If they're unsuccessful at that polling, they would go to a polling of New York banks. And you can see how that would be a challenge when there's a permanent discontinuation of LIBOR, and not really practical. So to take a look back, and Randy touched on some of these points on the timeline, so I won't hit everything on the top part of the timeline, but really kind of focus here on what's evolved over the last year or so in 2020. But again, just to give you some perspective and context for the history, going back to 2013, the Financial Stability Board, they went ahead and directed the national regulators to evaluate alternatives for LIBOR. That's when the Federal Reserve Bank and the New York Fed came out and announced that they will convene the alternative Alternative Reference Rate Committee as the industry body that will select the new index and move forward with the transitioning for the market. So that was convened in 2014. And then 2017, the summer of 2017, two big announcements that came out. One was from the ICE benchmark administrator, the Financial Conduct Authority. They did announce at that point that they were no longer going to compel the panel banks that Randy mentioned that serve as the data really behind LIBOR. They were going to no longer compel them to provide that data and those submissions after December of 2021. So they kind of let a 4-year timeline there, going back to June of 2017. Also in June of 2017, AARC announced that its preferred risk-free reference rate would be the secured overnight financing rate, which we'll talk a little bit more about in just a minute here. That SOFR rate is going to start publishing in 2018. It's a daily rate that gets published every day by the New York Fed. And then as we move into 2020, some kind of important announcements that we saw that came out last year. AARC released its updated LIBOR fallback language, and we're kind of focused on bilateral business loans because that's what really applies for the most part in the municipal space. So they came out with those recommended fallback procedures and methodology that was published in August 2020. ISDA also published what they have labeled their 2020 IBOR fallbacks protocol. And we'll compare both the ISDA published protocol and the AARC published fallback language here in just a minute, just to show you the context between those two. Also in November last year, an important announcement that came out from the LIBOR administrator ICE that they were going to start with a consultation with the panel banks on extending the publication of LIBOR out through June of 2023. So again, going back to June of 2017 announcement, this is really a 18-month extension of originally that December 2021 being the magical date. Now it's moved out to June of 2023. It's not confirmed yet. I think we're still waiting on final word on that consultation, but it's something that the market has accepted as a signal that LIBOR will continue to be published through June of 2023. Also, late last year, ISDA published its protocol that I mentioned, and then into January of this year, it becomes effective. So that protocol that several parties voluntarily would move into, that we'll talk about in just a minute, that went into effect in January 2021. And then looking forward into this year as we go, AARC continues to have a strong recommendation that no new LIBOR business loans are put in place, or if they are put in place, that they have robust fallback language. And certainly after 2021, they want an alternative reference rate to be used. So let's talk about SOFR for a minute here and some of the comparisons between SOFR and LIBOR. So again, AARC has identified SOFR as that alternative rate to LIBOR. Some of the differences as far as SOFR, how it's structured, and the comparison to LIBOR is that SOFR is considered a risk-free rate because it's based on underlying transactions that are collateralized with U.S. Treasuries. So it's considered a secured rate, where again, as Randy mentioned, LIBOR is an unsecured rate. Also to note that SOFR, one of the key things that AARC looked for in the replacement index is something that's going to be based on actual transactions, and SOFR is based on those actual transactions, where LIBOR, for the most part, it appears to be based on expert judgment at this point. So as I mentioned, SOFR is also an overnight rate. So again, that is a difference between what typically would be used for LIBOR type of contracts in the municipal space. They're typically going to be based on 1-month LIBOR or maybe 3-month LIBOR, but those are forward-looking term rates for LIBOR, where SOFR is an overnight rate that is published the following day. So as you can see, the takeaway here is that SOFR in itself will not equal LIBOR. So overnight SOFR does not equal 1-month LIBOR, and what will need to happen to move from a LIBOR-based contract to a SOFR-based contract is to take into account these differences, and by doing so, it's typically done through an adjustment to SOFR. And the idea here is that we want to get to a point where LIBOR is being replaced with an economic equivalent rate, which minimizes or, best case, eliminates any transfer of value. So here, there's a lot of information on this slide, but this just kind of gives you a comparison of the high-level points related to ARC's recommendation that they came out for bilateral loans last year, and then is the fallback protocol in the supplement as well. So just think of the ARC recommendations as what would probably apply to a business or a bilateral loan, and how you would approach that bilateral loan as you put that in place with your lender. Again, these recommendations lay out the product type, in this case being a bilateral loan, and then three key points that we're highlighting here: the fallback trigger events, what the benchmark would be, and what the adjustment would be. And you can see between the two of them, they are fairly consistent, but there's some subtle differences between them as well. So on the ARC, when we do a fallback trigger, the recommendation in ARC is that it could be triggered, the LIBOR trigger event could be done by the administrator, states that there's a permanent cessation. So that could happen. A regulator of LIBOR could make an announcement as well, or a public statement by the FCA that LIBOR no longer is representative. So really, either an announcement that it's no longer going to be published, or that the announcement states that it's no longer representative. And then with the recommendation with ARC that came out, the benchmark waterfall that they have, they start with what they label as term SOFR plus adjustment. And term SOFR is really a way for the banks to kind of get as close of a match to LIBOR as possible. As mentioned, LIBOR, if we look at 1 month LIBOR, it's a term rate that resets monthly, and it's in place for a 30-day period, a monthly period. Term SOFR doesn't exist yet in the market because of the just as far as the volume of SOFR isn't quite there yet to publish term SOFR. So we're highlighting that the adjusted SOFR is really probably the first item right now available in this waterfall. Adjusted SOFR based on a simple average in arrears. So taking 30 daily resets of that SOFR rate and averaging them over that period, and then plus the adjustment that we'll talk about in just a minute. And then the third in that waterfall is the lender selected rate plus an adjustment. And oftentimes when you go through this in a bilateral loan, it may not be exactly how ARC lays it out. The lender typically is going to be the author of that document, that contract, and they may have the waterfall in a different order here. Sometimes they'll start off with the lender selected rate. It may include a borrower consent or not. So things that you need to look for as you are evaluating that risk with the benchmark itself. And then the adjustment waterfall also is laid out with ARC's recommendation. It will start with either the ARC selected approach, which is noted that it's going to be the same as the ISDA selected approach, which is a 5-year look back. So they're going to take a look at LIBOR and compare that to SOFR over a 5-year period, do a median average of that, and that's going to be what's based on the adjustment. Or it could be a third lender selected approach as well. And again, on ISDA, you can see that there's a lot of similarities here as far as that fallback protocol. That's something that's available for participants who have existing swaps or derivatives in place. They can enter into the protocol voluntarily, and it would amend their documents to basically modernize the definitions that are under ISDA to now include this new methodology if LIBOR is discontinued. So that went into effect on January 25th for those who adhere to it. And any new transactions that would be entered into after January 25th of this year would automatically pick up this new language under ISDA. So you can see that the fallback trigger events are really identical to what is provided in the ARC recommendation. The benchmark waterfall is a little bit different where ISDA lays out that it's an adjusted SOFR rate, which is a compounded average over the period of time that we're looking at. Again, if it's 1 month LIBOR over a 30-day period, plus the adjustment, and then the waterfall on ISDA goes to a Fed recommended rate, overnight bank funding rate, and the FOMC target rate. And as I mentioned, also on that waterfall for the adjustment, it is based on a 5-year historical mean, taking a look at how LIBOR and SOFR have performed over that 5-year period to set that benchmark rate as far as that adjustment. So SOFR isn't necessarily the only option out there. There's going to be other alternatives that come up and surface, and some have already done that. One of the rates that have been, I guess, maybe focused in more so the news than necessarily in practice, but Ameribor is another rate out there that has had a lot of discussion around whether it's appropriate maybe for smaller or mid-sized banks to use. There are some kind of favorable points with Ameribor compared to SOFR if we're just looking at trying to make it as correlated to LIBOR as possible. So that would be the point that Ameribor is credit sensitive rate. It is based on the credit level of lenders. So that credit adjustments are already included in Ameribor. It is something that is tracked on an exchange. So and it is based on transactions as well. So it checks some of the boxes that would be deemed that you want to have in place if it's a new benchmark that's being used from an industry standard. Also, I want to mention on this slide here that this is the first CLE code reference. For those who are doing the CLE codes, you want to jot this down. It's code number 33501. And you can use that, I believe, at the end of the survey that you'll want to update that with that code number. There will be one more code at the end of the presentation as well. So this first code number 33501. Okay. On the outlook for LIBOR and what we've seen in the call it the tail end of 2020 or maybe the second half of 2020 and then moving into this year. So really what our experience is on the underwriting and bank placement side is that we continue to see a significant amount of the issuance in LIBOR-based transactions in 2020. So we know 95%. So again, that's based on our sample size that we're looking at primarily in the senior living, the healthcare, higher ed markets. But it continued to be the preferred index that was used in direct placement loans. But we did see that evolution of fallback language start to get incorporated. A lot of banks started, adhering to the ARC recommended language or some close form of that, which was helpful to kind of standardize or help standardize that marketplace. Some of the reasons, or the primary reason that we haven't necessarily seen banks roll out other rates as far as the index for bilateral loans is typically that the banks just operationally or administratively aren't quite there yet. I think there's been pretty significant progress over the last year or two, and what we expect is that will continue into this year, and probably a high expectation that SOFR will be an index that starts to be included in options as far as the underlying index for those bilateral loans. We also saw, again, as I noted, the ISDA fallback protocol that came out in late last year and then became effective. So there's been a tremendous amount of support for that fallback protocol that was put in place. On ISDA's website, you can track actually how many participants have adhered to it. It's over 13,000. So that's great to see. And many of those participants are municipal issuers and borrowers as well. And as it relates to, just as far as the SOFR derivative space, and if and when we see the SOFR start to roll out more frequently under the bilateral loans, there is a good amount of SOFR activity in the hedging space. So we're confident that as that happens, borrowers who want to convert that floating rate liability can do so through efficient ways in the hedging market. And then the last slide I'll end on here is just to give the audience a sense of that historical relationship that I mentioned with LIBOR and SOFR. So this is a graphical illustration that you can see that goes back to when SOFR began publishing data. You can see it goes back to 2018, and let's see if I can flip back. That data goes back to 2018, and the historical averages on that. Maybe get the screen to go back. There we go. So 1 month LIBOR averaged 1.523% during that time period. SOFR approximately 9 to 10 basis points lower at 1.431%. If we look at the graph, it might be a little hard to see on the screen, but the green line is the overnight SOFR rate that gets published daily. And you can see there's a little bit more volatility with that green line. When we take that green line and do a 30-day average of that, a simple average, over that, over those resets, you can see we moved to the black line, which is a little bit smoother and has a higher correlation with actual 1-month LIBOR term rates. And it's not a perfect correlation, and you can see just looking at this graph that there's been some experience with some decoupling. If we look at maybe December 18 through October of 19, and that one spike there that you see in October of 19 or September of 19, those are really due to a quarter end, year end of corporate rebalancing of the balance sheet. So kind of some technical trading sides of it where we see SOFR spike in those periods. There's been some level of correction there, and haven't seen those spikes really since that period. But one time period in particular occurred last spring after the COVID-19 started having some higher case levels in the U.S. We saw somewhat of a disruption or decoupling between SOFR and LIBOR as well, where SOFR was following the Fed's move of lowering short-term rates. It was moving lower as well, but at that time, if we look in the magnified box there of February 2020 to May of 2020, you can see that LIBOR actually moved up as a result of maybe some stress on the banks and their capital. So that was something that we saw and wanted to point out as well. I'm going to go ahead and hand it off to Josh here to move into the next section.
Thanks, Scott. So the next several slides will be focused on tax issues with respect to LIBOR. So let's see if I can get to that next first slide. Perfect. So in 2019, the IRS and Treasury came out with a combined statement basically saying that they felt it was appropriate to provide guidance on certain tax issues in order to minimize potential market disruption and to facilitate an orderly transition in connection with the phase out of LIBOR. So we have two main pronouncements, one from Treasury that came out in October of 2019 in the form of proposed regs called Guidance on the Transition from Interbank Offered Rates to Other Reference Rates. And then Treasury solicited comments. Based on the comments they received, the IRS came out with a Rev Proc in October of last year, which provides guidance to facilitate the transition from LIBOR to alternative reference rates through adoption of fallback language recommended by AARC and ISDA. We'll dive into the proposed regs and the Rev Proc. But before that, kind of a general question of, if I have a tax-exempt loan, why do I care that LIBOR is going away? Well, we care because we're trying to avoid a reissuance for tax purposes under the Treasury regs, under the 1001 regs. And the general provision in those regs is that changing the interest rate index in a bond or a swap from LIBOR to another rate index, if your debt instrument doesn't provide for specific guidance, could be a significant modification under the Treasury regs, which would ultimately lead to a reissuance. Scott earlier mentioned that the main documents that we're seeing LIBOR are in direct placements. And there's really kind of three types of direct placements when it comes to LIBOR. The first is that the loan is governed by the LIBOR index, period. There's no fallback language at all. There's no reference to anything that would happen if LIBOR goes away. Pretty clearly, if you were to amend that type of documents, you would have a reissuance for tax purposes, because you would really be changing terms, the debt instrument, that weren't contemplated. A second type is, if LIBOR goes away, we're going to replace it with index X. And that would be a great provision. You wouldn't have a reissuance there, because your documents would tell you, okay, LIBOR's gone, replace it with this. The vast majority of loan agreements that are outstanding, and the vast majority of probably participants in this seminar, in this webinar, are dealing with kind of the third type, which says, if LIBOR goes away, we, the lender, will work with you, the borrower, to find a replacement rate, to find something that works for everybody. So the question really becomes, well, what does that mean, and can we avoid a reissuance? So what's the big deal with a reissuance? Why should we care if there is a reissuance? For issuers and borrowers, reissued tax-exempt bonds could have to meet the same requirements that you that you had to go through on the day you issued the bonds. So things like authorization issues have to go back to the issuer of your bonds to get approval to make the change. If you're a 501c3 bond or a private activity bond, things like a new TEFRA hearing. If you're a housing bond, you had to deal with volume cap. These are all things that you're going to have to consider at the time of reissuance, filing a new 8038, any arbitrage or rebate requirements you'd have to think about. And then, of course, getting a new bond opinion that the change wouldn't cause an adverse tax consequence. So while it doesn't sound like it would be that difficult if a lender comes to you and says, hey, let's change from LIBOR to this other index, all it is a one-page document, that might be right for the contract, but unfortunately, there could be tax consequences that could really hinder your ability to do things on a quick time frame. You'd have to kind of go through all those steps. Scott had mentioned swaps, and swaps that were entered into at the time that you entered into your tax-exempt bonds or that are hedged with respect to your bonds could cause a whole other range of problems. If your swap counterparty tells you, we want to replace LIBOR with X index, but that's different from the index that your loan counterparty wants to deal with, that could cause a deemed termination of the swap. It could cause the swap to not be a qualified hedge. So all have tax consequences if you're dealing with LIBOR-based swaps. So the IRS rides to the rescue. The IRS understood that this is a problem and we need to provide some guidance to people that are dealing with LIBOR-based loans. So the proposed regs that came out in 2019 provide that if the terms of a debt instrument are modified to replace or to provide a fallback to LIBOR as a reference rate with what they call a qualified rate, which we're going to talk about, and the modification doesn't change fair market value, again, we'll talk about fair market value, then the modification won't result in a reissuance. And one of the nice things that was in the proposed regs was that applies whether the modification is by an amendment to the existing debt instrument or by exchange of a new debt instrument. So that was an important point that was contained in the regs. The regs also state that an associated alteration, which we'll talk about, will not result in a reissuance. One of the examples that they give with respect to an associated alteration is the obligation of one party to make a one-time payment in connection with the replacement of LIBOR to get to a level of the new rate. So the next few slides, we'll talk about what a qualified rate is, what's fair market value, and what is an associated alteration. Okay, so qualified rate. In order to be a qualified rate, there's a three-part test, and unfortunately, you have to meet all three to satisfy the definition. The first is probably the easiest one. You have to be one of the rates listed in the proposed regs, and the proposed regs actually list 12 different options. One of them is SOFR, which we've talked about. The others that are listed are other indices that I'm not aware of any bank loans actually looking at these. Things like the Tokyo overnight average rate, the Swiss average rate overnight, the Hong Kong dollar overnight index, as well as some others. The one provision that is very helpful with respect to qualified rate is any alternative substitute or successor rate that's selected, endorsed, or recommended by the central bank, the Reserve Bank, or similar institution as a replacement for LIBOR. So that really leaves open the possibility that if down the road another rate, SOFR 2 or something else comes that's endorsed by AARC or ISDA or another entity, could fall within that qualified rate without having to issue another reg. The second is that the modified instrument must have a substantially equivalent fair market value to the original instrument. And the proposed regs provide two safe harbors there that we'll talk about. The third, which doesn't impact municipal bonds, is just that it's conducted in the same currency. So we're not going to focus on the third. We'll focus on the first two. So, the safe harbors that I mentioned, the main question is whether the fair market value of the debt instrument after the alteration or the modification is substantially equivalent to the fair market value before the alteration or the modification. And again, I think the IRS recognized that might be difficult to determine. So they provided two additional safe harbors. One, the historic average of rates, and two, arm's length negotiations. So the historic average of rates, how would we satisfy that? This one, pretty standard, as you see with reissuance, basically says that if the time of the alteration, your historic LIBOR rate is within 25 basis points of the historic average rate that replaces it, then you're within the safe harbor. And the parties can use any reasonable method to compute historic average. The two limitations that are mentioned in there really have to do with the historic data, the timing that you use it, and that you're being consistent with the data that you're using. And parties can also compute historic average in accordance with an industry-wide standard. So we talked, Scott talked a little bit about historic averages set forth in ISDA and AARC. Apparently they're working on historical averages for SOFR, being that it looks like SOFR is going to be the approved fallback rate. The arm's length negotiation safe harbor, this one is met if the two parties aren't related and they have a bona fide arm's length negotiation over the alteration or modification. The big question here is whether bond counsel is going to be able to rely on a recital or a rep from the parties that, this was a fair market value, this was an arm's length transaction. And then the question is, well, who's required to make that determination? Is it the issuer? Is it the lender? Is it the bondholders? The regs don't really provide guidance there. So that's something that's still up for debate. Associated alterations, we spoke a little bit about that when we first started here. And the proposed regs basically say that an associated alteration is not a reissuance for tax purposes. And it's any alteration that is connected with the replacement of LIBOR that's reasonably necessary to adopt or implement that replacement or inclusion. So, an example of that would be a change to the definition of the interest period or a change in timing of the frequency of the payment. And they also provided that an obligation of one party to make a payment in connection with the replacement of LIBOR wouldn't result in a reissuance. So let me go back here. Sorry, try to go back. Chris, if you can get me back to status of the proposed regs.
Josh, I think you need to give control back.
Okay.
You can.
Okay. One more. Perfect. Thank you. So the proposed regs haven't been adopted as final regs, but a taxpayer is able to use them as long as you use them from and after October 9th of 2019. In their comments for solicitation, the IRS got a lot of comments, and they looked to the ARC fallback and the ISDA protocol in issuing RevPOC 2020-44. So 2020-44. Perfect. That allows bonds and swap documents to be modified now to provide for LIBOR alternatives without risking a reissuance. And those modifications won't result as long as the fallback language is that provided by ARC or ISDA. Any modification occurring on or after October 9th, 2020 and before January 1, 2023 should be used now. As Scott mentioned, any new LIBOR loan that people are entering into really should have what they call the hardwire fallback language. And that is the language that's right in the RevProc. So if you're in the process of negotiating a LIBOR-based loan, you really should have that fallback language. So with that, I'm going to turn it over to Randy.
Thanks, Josh. Okay, go to the next slide here. So LIBOR isn't all just the IRS and tax law. There's also a, hold on, one more. There's also a securities component, and the SEC has jumped in through its Office of Municipal Securities, which is the office of the SEC that coordinates the SEC's municipal securities activities and administers SEC rules, which pertain to municipal security brokers and dealers, municipal advisors, and issuers. The Office of Municipal Securities wants municipal obligors, either issuers or conduit borrowers, to consider the need to make appropriate disclosures regarding material risks related to the expected discontinuation of LIBOR and the mitigating actions it's taken in response to that. Basically, it wants its official statements to look better in terms of disclosure of LIBOR risks. They would like the LIBOR to address any LIBOR issues if there's an interest rate or if there's a swap relating to the bond. They want disclosures regarding the material risks related to the discontinuation of LIBOR, the actions that are being taken or expect to be taken in response to any risk, and discussion of the fallback language, such as Josh mentioned, regarding the LIBOR discontinuation. The National Association of Bondholders is actually preparing some suggested language to use in the official statement to discuss issues regarding LIBOR. That is being worked on now, and it will probably come out later in the spring, so people could use that to add to their official statements. Basically, though, the SEC and the OMS want issuers and conduit borrowers to keep their bondholders informed, either through disclosures that are required by continuing disclosure agreements or by making voluntary disclosures on their EMA website. They wanted to show that what progress they're making towards LIBOR risk identification and mitigation and any material anticipated impact on the issuer or the conduit borrower. And finally, and Amy will discuss this later, if there's any financial statements that are included in the OS or in any EMA postings, the issuer, the borrower, should be aware of any of the new GASB and FASB accounting standards with regard to the LIBOR transition. So not only will issuers and borrowers have to worry about all this, but also municipal advisors. The SEC's Division of Examinations announced a risk alert that intends to basically examine SEC registered MAs to assess their preparations for the discontinuation of LIBOR. The MSRB, the Municipal Securities Rulemaking Board, also said that under Rule G42, if an MA recommends a municipal securities transaction or financial product involving LIBOR to a client, the MA has to have a reasonable basis to do so. OMS is also reminding MAs that under the Exchange Act, they have a fiduciary duty on advising municipalities, so they have to be aware of any issues relating to the LIBOR transition. So basically the message is, if you're an MA, you have to let your clients know about the LIBOR transition and what it entails. And now Amy will jump into ongoing matters about that.
Great, thanks, Randy. So we're going to take just the next 5 minutes or so to talk a little bit about some accounting issues, some things that are happening legislative-wise, and then really next steps for borrowers, summing up lots of what Scott and Randy and Josh talked about. So first of all, for accounting, really, we do just want organizations to be aware of and talk with your accountants about how this LIBOR transition will have implications for financial statements. And as Randy mentioned, in particular, any financial statements that you expect to go into offering documents. I think certainly as a reminder, folks know GASB sets accounting standards for governmental entities. FASB sets accounting standards for conduit borrowers and non-governmental entities. Both have issued statements, GASB's statement number 93 and FASB issued topic 848 on reference rate reform. Please talk with your accountants. A lot of this is still evolving. We know FASB issued an update to this topic 848 just in January. So make sure that you talk with your auditors about any implications for financial statements. And then for possible legislative solutions, so there has been legislation introduced in the New York State Legislature to add a new article to the New York State UCC for contracts governed by New York law. And essentially, the law is intended to minimize any costly or disruptive litigation by providing some legal certainty around the issues that are likely to arise under New York law. This is Bill S-9070. It is expected to be acted on in 2021. And for LIBOR-based contracts that contain no fallback provisions or fallback provisions that rely on a solicitation of quotes, the bill would replace LIBOR with a replacement indexed base rate recommended by the Federal Reserve Board, the Federal Reserve Bank of New York, or ARC, which Scott had talked about upon the occurrence of one of the ARC triggering events. I think there are certainly questions around this New York law, one of which would it run up against constitutional prohibition against laws impairing the obligations of contracts. It would only affect New York contracts. So there is, we understand, a U.S. House subcommittee looking at federal legislation substantially similar to the New York bill that could provide a national solution. And just yesterday, Federal Reserve Chairman Powell voiced his support for some national legislation to ensure a smooth transition. So we'll certainly keep a watch on that. And it looks like this is our second CLE code. So for those looking to get CLE, code number 2 is 61035. So again, that's 61035. So in conclusion, really, what are some of the next steps for borrowers? I think you primarily need to figure out what you have and who you need to start talking with. So inventory and identify, all of your existing LIBOR-based contracts. Determine which of these contracts may extend past the new LIBOR cutoff date. Determine how that contract may be amended or modified to address any issues. Develop a remediation strategy. In particular, start talking with people. Determine if modifications should reference SOFR or another alternative, or any other factors in modifying these existing contracts. Make sure that the contract incorporates effective fallback language, including appropriate spread adjustment provisions and trigger events. Understand, and Josh mentioned this, who will control what that new reference rate will be for the contract. Do you have any say in that decision? And if you don't, determine if you can refinance or redeem if you don't like the new rate, and any potential penalties you might have to pay to do so. If you're entering into a new LIBOR-based loan and intend to hedge that loan with a swap, you make sure that there's no disconnect between the fallback rate on the loan and the fallback rate on the swap, and understand any potential mismatch there. Randy had talked about disclosure. So certainly we encourage appropriate disclosures regarding any material risks relating to the discontinuation of LIBOR and how that's being mitigated. Discuss with your bond counsel, your disclosure counsel, or your dissemination agent if any contract changes would trigger a material event filing, or if you should submit a voluntary disclosure filing on EMMA regarding any changes. And lastly, consult with your finance team if you're asked by any lenders or derivatives counterparties to adhere to the ISDA protocol or execute an amendment to update any fallback rates when you're working through the transition. I think in bank loans and direct placements, as Josh mentioned, you discuss with your bank the replacement rate that will be used for LIBOR contracts, request to review with the bank any financial penalties that may occur. And then lastly, you certainly consult with your auditors as all of this evolves on any accounting matters, such as GASB 93 or FASB's Topic 848 to understand how this could flow through your financial statements. And I think with that, we're all wrapped up with the formal part of the presentation, and it looks like we may have a few questions here. Sylvia, I'll turn it over to you.
One of the questions that was posed through the toolbox is, it might be for either Amy or Scott. Is it expected that banks will use a consistent spread adjustment from LIBOR to SOFR? I don't know if either one of you want to jump on
it.
it.
Looks like Scott's taking the lead on that, but he might still be on mute.
All right. Okay, I think you can hear me now. So as far as the spread adjustment on bank loans, I think it really will go back to what your contract states. Who's in control of that, and if there is any, I guess, methodology on a spread itself, how it's calculated. Is it something that the lender's calculating that may not be completely consistent with the industry standards that are being set by ARC and ISDA. So I think on that front, you really want to pay attention to the details of your contract and the loan. If it's more related to a derivative, that will be standardized. All swap transactions or any type of derivative transaction that adheres to the IBOR fallback. Or is being executed after January 2021 that automatically picks up that language. Those will be standardized, and those will all be set at the same exact spread adjustment.
Thanks, Scott. And we have another question here. I know we're coming up to the 1 hour mark, but we can try to squeeze this one in before finalizing the webinar. The question is that if a borrower has a LIBOR-based swap on a letter of credit-backed bonds, is that situation when disclosure language would need to be published, even if it does not have a continuing disclosure requirement? I would punt that to either probably Randy or Josh, or get your thoughts, Amy, as an investment banker there.
If I were underwriters counsel, I would want that disclosed, yes. Whether or not there's a continuing disclosure obligation to do so, I think it would probably be something you'd want to put on Emma. I think the SEC is taking a pretty strong stance on trying to get as much disclosure on LIBOR issues as possible. So,
right, and Randy, I would agree with you. We know there has been a focus on increased disclosure around all things bank related. So I think this likely falls into that category.
Great. So we're now, hitting up on the 1 o'clock hour. I think that is kind of indication that this will conclude our webinar for today. Thank you so much to all of our panelists for your time and your expertise and your thoughts. And I also want to thank the Saul Ewing, Arnstein & Lear marketing team for all their effort in putting this presentation together and getting it casted out to everyone live. Remember to keep an eye out for the thank you email with links to the webinar presentation materials, the program recording, and the all-important CLE reporting survey. If you have any questions, you can always follow up with any of us. Our presentation materials contain our contact information. Thank you very much.